Now, President William Ruto has appointed the third cohort of commissioners to the National Land Commission. These appointments come at a time when, as soon as he nominated individuals for vetting to Parliament, and that happened on March 12th, what happened is that the Institute of Surveyors of Kenya raised questions and wondered how none of its members or a professional with experience in matters to do with land administration and adjudication was actually appointed. Now, according to Section 8.1 and Section 8.2 of the National Land Commission Act, the individuals nominated or appointed to serve in the commission should ideally have requisite skills on, and I quote, land law, land survey, spatial planning, or land economics as recognized relevant fields of expertise for appointment to the commission. Now, what does that mean? Did the president break or violate the law in appointing individuals that, according to the ISK, are not land professionals and therefore incompetent to serve in the commission? Well, this is an issue that again brings to the fore the controversies that surround the National Land Commission since its establishment. But what we are going to look at in this expose is something to do with cannibalistic behavior that we are seeing during transition time, where a lot of monkey business goes on in the commission, and in this case the controversies are far from over. During this transition period, Kurunzi News is seized of material that bear evidence to activities at the commission which may have led or could lead to further loss of public funds in the commission, especially as far as matters to do with compensation of land acquired for government projects is concerned. And we are going to look at some key projects that would give an idea of how much and how money is lost through fictitious compensation and blatant violation of the laid down procedures when it comes to how and what should be compensated when land for public projects is being acquired. Since its establishment, the National Land Commission has been embroiled in multiple scandals involving fraudulent compensation, abuse of office, and corruption, among others. Amongst the notable are the SGR compensation scandal, Nairobi Expressway land payments, the Ruaraka land scandal, irregular land allocations, and withheld compensations for individuals with no resources to oil the hands in order to expedite processing of the payments, or in other words, to engage in corruption. Now it appears the problems at the commission are far from over. Kurunzi News is seized of information that reveals recent activities at the commission which may have led or could lead to further loss of public funds through suspicious compensations, coming at a crucial transition period between the second and third commissions. Before we delve into the gist of the matter, it is important to understand the valuation and compensation process. Under the Commission's compensation framework, valuations are categorized into three schedules. Schedule A covers payable private land where ownership and payee is verifiable. Schedule B applies to land where either ownership and or the payee cannot be determined and is therefore unpayable. Schedule C applies strictly to public land which belongs to the government and does not therefore attract any compensation. Pay attention to this information as we shall revisit this as we move forward with our investigation. Earlier on, we talked about the SGR land compensation, which happened during the Commission's first cohort led by Mohamed Swazuri. It seems the ghosts of this scandal are still with us. Details are emerging on how compensation claims on parcels of land LR number 10424, originally registered in the name of East African Portland Cement Company Limited, now East African Portland Cement PLC. According to documents seen by Kurunzi News, this land was first gazetted for acquisition on 25th July 2014 for 42.989 hectares. The proprietor, who by then EAPCC, was awarded and paid 610,880,000 shillings based on a market valuation of 5 million shillings per acre. Subsequently, through Gazette Notice number 7090 of 10th October 2014, an additional 39.259 hectares were gazetted. On 22nd April 2016, a further 4.6054 hectares were added, records showing that the Commission did not award or pay compensation for the additional 39.259 hectares at the time, despite possession having been taken for the SGR project under Kenya Railways. In December of 2021, the original parcel was subdivided into LR number 10424/1, 10424/2, and 10424/3. The parent title ceased to exist following the subdivision, even though the additional acquired land had not been compensated. History has shown us that land grabbing schemes are usually enabled through subdivision and amalgamation, so that the history of land and original title numbers are lost. Was this subdivision aimed at causing confusion on the ownership of the land? This failure to compensate at the time of acquisition led to accrued interest according to Section 177 of the Land Act. Remember, by the time of acquisition, the owner of this land was East Africa Portland Cement Corporation, which was a government parastatal. Remember the valuation schedules we talked about earlier? If this is the case, why was land which falls under Schedule C compensated? Again, why was compensation for the additional land delayed so as to attract hefty interests? Was public money lost in the process? Another interesting story unfolding in the tourism city of Mombasa is also something that has caught our attention. In 2021, the government came up with plans to build a bridge over the Likoni Ferry Channel, connecting Mombasa Island with the mainland. Now, this was meant to facilitate movement of traffic and ease congestion at the channel, currently served by the ferries. And on this one, there is more than just meets the eye. When the National Land Commission received notice of intention to acquire project land via Gazette Notice number 12299 of 12th November 2021, they identified a total of 2,189 as person affected by the project, referred to as PAPs. Of particular interest is the valuation and compensation claim on parcels Mombasa/MS/Block 1/107 and Mombasa/MS/Block 1/108 in Likoni area. According to land records, these two parcels of land were owned by Alba Petroleum Limited, an oil company based in Mombasa whose main business interest is importing and exporting petroleum products. Kurunzi News has seen documents showing the two blocks were valued at 546,367,300 shillings. However, Alba Petroleum claimed compensation for what they called land improvements, loss of business and reimbursable costs totaling a staggering 1.14 billion shillings, more than double the original land valuation. In submissions reviewed for this investigation, the company presented documents outlining ambitious future investments, including plans to build a factory and a jetty. The discrepancy has triggered sharp questions about the basis of the figures. Critically, documents note that, and I quote, "The land still remains vacant with no tangible investment in place," unquote. That observation undercuts the scale of the compensation demand and raises concerns about speculative claims tied to the proposed rather than existing developments. Investigators further flagged that the value of land seems to have been inflated given the cost of property in the Likoni area. If accurate, that finding suggests potential over-evaluation of public funds in a project already under fiscal pressure. Perhaps most shocking is the assertion that, and I quote, "NLC made compensation on fictitious claims against laid down procedures," end quote. Compensation frameworks under Kenyan law are designed to cover legally recognized interests, typically tied to verifiable developments or improvements. Paying out for concepts or future projections would make a significant procedural breach. Documents seen by Kurunzi News reveal that a schedule of payment totaling over 11 billion, that is inclusive of Alba claims, were prepared and sent to Kenha to provide funds for payment. Question: what informed the National Land Commission's decisions to compensate futuristic or intangible reimbursables? Did the Commission carry out a forensic audit on these claims? And if so, where is the audit report? Meanwhile, in Nairobi, another scandal is unfolding, this time around the Eastern Missing Links Roads project, a continuing infrastructure initiative involving the expansion and construction of several link roads within the capital city. Following a request from the acquiring authority, the Kenya Urban Roads Authority, KURA, through a letter dated September 11, 2025, the Commission published an addendum and inquiry notice via Kenya Gazette Notice number 13848 of September 26, 2025. The affected parcel, LR number 209/12839, is claimed by Nyagoto Investments Limited. However, the history of the parcel of land reveals a tangled legal saga. The land had previously been revoked by the land registrar through Gazette Notice number 9230 of July 2011 because it had been reserved for public purposes. It was later subdivided into LR number 209/12839/1, approximately 0.1 0.212 hectares utilized for road construction, and LR number 209/21706 approximately 0.0607 hectares, which remained registered under Nyagoto Investments Limited. Remember what we said about suspicious subdivisions and amalgamations? Does that ring a bell? However, the revocation was successfully challenged and nullified by the High Court of Kenya, restoring the company's claim. The overlapping timelines, revocation, subdivision, road construction, court nullification, and fresh inquiry expose systemic tensions between public infrastructure expansion and private property rights. They also raise concerns about coordination between state agencies, land registries, and the Commission during compulsory acquisition processes. Another scandal involves land historically reserved for government agencies dating way back to 1974. If you are a regular visitor in Nairobi's community area, you may have noticed that there is a vacant plot opposite the Milimani Law Courts and adjacent to the NSSF parking silo. This piece of land, originally registered as LR 209/13708 and currently fenced with blue iron sheets, has a story to tell, and it's not a good one. On May 7th, 2025, the National Land Commission received instructions from the Cabinet Secretary for Labor and Social Protection, requiring them to undertake compulsory acquisition of the said parcel to, quote, facilitate critical operational requirements for the national headquarters of NSSF, which is to host 4 ministries, several departments and agencies, end quote. The same report also states the acquiring body was Kenya Urban Roads Authority, KURA. The jury is still out on whether this is a clerical error or another tactic to cause confusion to the acquisition process. When the Commission commenced an inquiry process to ascertain actual ownership, they found the title is currently held by Grassy Limited. While historical records indicate the parcel of land was reserved for government use, documents attached to the report reveal how the property transitioned into private ownership. A company named Kurunzi Stores presented a letter dated 24th July 1998 indicating the allocation of the land by then President Daniel Arap Moi after making a payment of 5.2 million shillings. Due diligence conducted through the Ministry of Lands corroborated the allocation. Additional affidavits from Ephantas Murage Mundia and Wetangula and Adan advocates affirmed the allocation process. The land subsequently changed hands several times. On 29th March 2006, it was transferred to Auto Silo Queensway Limited for 65 million shillings. On 28th December of 2011, it was transferred to Frontier Properties for 100 million. On 24th December 2024, it was transferred to Grassy Limited for 500 million shillings. They are listed as the current owners and have since had the title converted to NRB Block 30/19. The escalation in value from 5.2 million to 500 million occurred despite the historical classification as land reserved for government agencies. The documentation trail demonstrates how public land was privatized, traded, and ultimately positioned for compensation at dramatically inflated figures. Worse still, documents indicate the Ministry of Lands valued the parcel at 610 million shillings, while the National Land Commission gave it a value of 731,600,000 shillings, a figure way above the permissible variance in the valuation practice. This raises two fundamental questions. One, is this a scenario where public land changed hands to private property at a pittance, then acquired by the state at highly exaggerated rates? Number two, why did the final payout violate the principle of permissible variance? What informed the final decision? These hard questions cannot be adequately addressed without looking at the faces behind crucial decisions at the National Land Commission. It is important to note that these scandals revolve around compensation claims arising from mega government projects. And isn't it curious that only money in hundreds of millions and billions is involved when it comes to these scandals? The National Land Commission is the only body mandated to acquire land on behalf of any government entity in need of it. The National Land Commission is the only body mandated to acquire land on behalf of any government entity in need of it. Once the notice of intent to acquire is served, the NLC's valuation department, currently headed by one Joel Ombati Nyamweya, commences the evaluation process. This ends at the Commission's plenary, where final decisions, whether to compensate or not, are made by way of resolutions. Details seen by Kurunzi News seem to indicate that Ombati, who joined the Commission on August 3, 2025, has been instrumental in fast-tracking the valuation processes and payments of the contentious files, some dating back to the Swazuri era. Before joining the Commission, Mr. Ombati was working at the Kisii County government. Emerging details indicate his name could still be in the county payroll. According to information available at the Commission's website, Joel is described as a land and valuation expert with over 20 years' experience in valuation, property management, land acquisition, and resettlement. He holds a bachelor's degree in land economics and a master's degree in valuation and property management from the University of Nairobi. Since joining the Commission, he seems to have struck synergy with the Commission CEO and Secretary Kabale Tache Arero. Kabale served as acting CEO in December 2018 and worked in the same position until June of 2023, when she was confirmed as the substantive CEO. The Commission's website describes her as a seasoned career professional with over 20 years' experience in human resource management. Now, the fight against corruption in key government projects appears to have been abandoned, with stakeholders, whistleblowers, and the media repeatedly reporting mega scams on a daily basis. This is certainly not the first that Kurunzi is exposing, and will not be the last one. Every public coin lost in corruption impacts service delivery, and with institutions meant to investigate appearing either complacent or uninterested, or nobody really understands what happens, because these cases come to the fore, but they don't seem to be prosecuted and the authorities barely scratch the surface. The biggest question is, how do these scandals continue to happen, yet the DCI, the EACC, the National Intelligence Service, and all agencies of state are actually properly resourced, and the country has more times without number been told why it is justified to allocate resources in billions to these entities so that they can deal with issues like this, to avert Kenyans losing billions of money through projects like we have seen in this expose. It is time that those given the responsibility to act on behalf of the public do so in the best interest of the public, and where they do not, then those given the power to prosecute after detailed investigations, they must do their job. And if they do not, then they too must be held accountable.